So welcome everyone, and thanks for joining us for this webinar this morning. It's the second webinar that the housing team are delivering on public sector equality duty. This time we're looking at possession claims. The previous webinar that we did last week on the duty in the homelessness context is available to watch on our website. And this webinar will also be available on our website shortly after we finish. I should say as well, you can find a range of other webinars relating to other practice areas that we cover in Chambers there as well, if you'll have a look if you're interested. Unfortunately, we didn't provide for any questions in advance this time round, but you will see there's the question and answer function on the Zoom control panel. So do feel free as we go along during the presentation to ask questions. We will have a question and answer section at the end, and we'll try to cover as much of that material as we can.
I can't hear that, sorry.
So can you hear me now?
Yeah, yes I can, yeah. Okay, now we can see you, I think.
Andy, you need to put yourself on mute at the moment. Sorry everyone, we've been having a few technical difficulties with Andy's camera, so hopefully that will be resolved by the time we get to him. But yes, if we don't get to deal with the questions that you asked us on the Q&A panel, then you can always follow up with us afterwards. So without further ado, I'll move on just to outline what we're going to be covering today. I'm going to start with just a brief introduction to the public sector equality duty and how it applies in possession claims. You'll then be taken through a case law update by Ryan and Rucci, and they're going to tell you in particular about the Court of Appeal recent judgment in Luton and Durdana. And then Andy will take over, hopefully his technical issues will be resolved, and look at some practical tips for decision makers and how to apply the public sector equality duty in practice. And then, as I said, we'll have questions and answers at the end. So just by way of introduction then, I'm sure many of you will be familiar with Section 149, part of it is shown on your screen there. It has been described as an abstract formulation of what has to be done, and it has to be said it's not the most clearly drafted section. It does apply to all functions of a public authority, so at all stages of possession claims, it's something that needs to be taken into account. It is a duty that's engaged where a person has a protected characteristic which is relevant to the decision in question. So in possession claims, that usually will arise due to the tenant having disabilities, in particular mental ill health, which might impact on their behaviour, but it's obviously not limited to that. You'll see from the emboldened text, it's a duty to have due regard to certain statutory aims. And for the purposes of possession claims, probably the key aim is going to be advancing equality of opportunity, and further parts of the section confirm that that includes taking account of people's disabilities where they have disabilities. So that's probably how it will mostly arise in possession claims. Oh, sorry, I've somehow managed to skip through. Oh, there we go. Right, sorry about that. So how does the duty feature in possession claims? Usually it will be raised by way of a defence, often as part of a wider Equality Act claim. So it might be bundled together with indirect discrimination allegations, failure to make reasonable adjustments, and so on. Just to note, a breach of the duty doesn't give rise to damages, so it's not appropriate to see it in a counterclaim. It will often just be pleaded as a bare allegation. Sometimes has the appearance of a bit of an add-on really, although in many of the cases that have gone to the higher courts, it's assumed a greater significance on appeal. And as I said before, the duty arises at all stages of possession proceedings. So it will be featuring in claims by way of defence to the possession order itself, or it might be raised on an application to suspend a warrant, or in other applications that might be made, but only when the landlord is on notice that there is a relevant protected characteristic. And I should say the stage at which the issue is raised will be relevant to what the court would expect to see by way of compliance, and that's something that Rucci is going to be covering in a bit more detail later on. So just running through, I suppose, some of the key points that have emerged from the case law, not just in possession claims, but generally, in terms of how to go about complying with the duty. It's a duty that's to be complied with before a decision is made, needs to be approached with an open mind. It might, though, be possible to rescue the situation later on, and that again is a topic covered in some of the recent case law which Ryan and Rucci will be dealing with. It's a general regard to equality issues isn't sufficient. Judges have used words like conscientious and rigorous. There's a need to have a specific regard to whatever the protected characteristic is that's an issue, what impact it has, and what the consequences of possession would be. So just general references to equality issues is not going to be sufficient. It is a question of substance and not form. So the court would be interested in more the reasoning and the thought process that's been carried out, not whether the duty has been recited correctly or a particular form has been filled in. And it might require some information to be gathered before a decision is made. And in any event, that might be time saving or avoid later issues once proceedings have begun, if there is a bit more investigation done at the outset. And then it's a continuing duty. As I said, it applies at all stages. So it's something that should be reconsidered as facts change and at each stage. The duty can't be delegated. That's particularly important where decisions may be being taken by a more senior officer following consideration by someone more junior. So any report that's going to be approved would need to set out consideration of the public sector equality duties so that the person actually taking the decision can say they've had the due regard that's needed. Point 7, creating a record of how the duty is being considered. Obviously, it can be hard to prove compliance if you haven't got any paper trail. And there's no legal requirement for a written decision to start possession proceedings, unlike other contexts. For example, homelessness that we discussed last week, you have to write decision letters, so it's easier, I suppose, to comply with the duty and show that you have. So it may be that a change of procedure is needed, depending on what your procedures are, when you're going through the consideration of possession proceedings in order to show that that has been complied with. And then finally, it's a question of process, not outcomes. And I think Andy's going to touch on that later. So that's all I want to say by way of introduction. And I'm going to hand over with the case law update, and I think Ryan's going to kick us off. So Ryan, over to you.
Thanks very much, Emma. And a recent demonstration of all the points that Emma has just highlighted is in a 2020 case from the Court of Appeal of Luton Community Housing and Durdana. Some of you may be familiar with the facts, but just a brief overview of them. Miss Durdana and her husband were tenants of the housing association, and the younger of their two children suffered from a disability within the meaning of the Act, namely cerebral palsy. Now, when applying for homelessness assistance to the local authority, it was established that they had in fact lied about where they'd been previously living and about the circumstances in which they had become homeless, as well as their level of savings. And that lie was established through Ms. Durdana accepting a formal caution in March 2017 as a result of those matters, and her husband in fact being convicted of providing false information to obtain housing. So as a result of those circumstances, unsurprisingly, the Housing Association served a notice of seeking possession, relying on ground 17, and equally unsurprisingly, if we move to the next slide, you will see that possession proceedings were defended on the basis that the Housing Association failed to perform its public sector equality duty, and specifically that it failed to consider in advance the impact of seeking possession and obtaining possession on the Durdana family. Now, in the county court, that was sufficient for the judge to dismiss the possession claim on the basis that no public sector equality duty assessment had been carried out, and thus the judge determined it would be unreasonable to make an order for possession. However, on appeal to the Court of Appeal, the Court of Appeal reminded us of the principle that was established in Powell and Decorum in 2019, namely that the scope for action under Section 149 will vary depending on the function being performed. The question for the court to analyse is context specific. And moving to the next slide, you will see that in any case, it's important to commence a consideration of the public sector equality duty by actually having by actually thinking about which part of Section 149 is engaged. Now, in most possession proceedings, in our experience, it is the need to have due regard to the need to advance equality of opportunity between disabled and non-disabled people, and specifically due regard to the need to take steps to meet the needs of disabled individuals, which may be different from non-disabled individuals. A mouthful, but those are the two elements of the public sector equality duty which usually come up, certainly in my experience. Now, what the Court of Appeal said in Durdana is that it is only in a rare case that it is possible to comply with the duty in ignorance of its terms. And that's why it's really important that your officers are aware of its terms. There are a lot of situations that I come across where officers are simply unaware of the terms of the public sector equality duty. And as Emma alluded to, that audit trail of decision making of showing that they have given active consideration to which part of the public sector equality duty is key. And that is the message we're getting from the Court of Appeal in Durdana. But the Court of Appeal also reminded us that in last year's decision of Aldwick and Forward, a court should refuse to dismiss a possession claim where there is a breach of the public sector equality duty if the court is satisfied that it is highly likely that the outcome would not be substantially different if the breach had not occurred. So in essence, what the court is saying is that even if the duty is not complied with, the court isn't automatically going to throw out a possession claim. It's going to think for itself, what would be the impact of the duty if it had been complied with, and if the impact would have made no difference on the decision to take possession or to continue possession proceedings, then the court will not dismiss them on the basis that there has been a breach of Section 149. And if we move to the next slide, the court reminded us that on the facts of Durdana, again, context specific, very important to analyse the facts of any individual case, but on the facts of Durdana, the respondent's daughter's disability imposed certain physical limitations on her ability to move around freely and on her ability to communicate. So this is the court reminding us that it's important to focus on the actual impacts of the disability and then go on to consider the question of proportionality. The evidence in the case of Durdana was that Ms. Durdana's daughter did not need particular facilities according to the medical evidence, and the state of her general health was good. The court could not conclude that a move to other accommodation would impact on her disproportionately as a result of those disabilities, but there may be some impact which is not irreversible. So these are the sorts of questions and conclusions the court would ordinarily be looking to the local authority or the housing association to have come, but if they don't consider it or they don't correctly carry out the process, then the court will consider these matters for themselves. And at paragraph 35 of the judgment, the key question was whether the housing association, in paying due regard to that medical evidence and in considering whether it was still appropriate to seek possession, it was highly likely that the housing association would have made the same decision to have proceeded with possession, and the court concluded in Durdana that it would have done. There was much reliance in Durdana on the case of Aldwick and Forward, which was another Court of Appeal case the previous year. And that was a possession claim against an assured tenant who had committed various criminal offences, including drug dealing at the property. Possession was sought under ground 14. Now, the defendant in Forward was physically disabled. There had been a PSED assessment, but that assessment was carried out in circumstances where it was conceded that it was inadequate because no medical evidence had been obtained about the defendant's disabilities. But the High Court dismissed an appeal against the possession order that was granted in the County Court on the basis that the carrying out of an appropriate assessment would still have resulted in a possession claim proceeding. So there was no point in requiring that to be done for the sake of form rather than substance. So if we move to the next slide. The Court of Appeal on the appeal of Forward determined that there was no principle that once you had breached the PSED because you hadn't carried it out, that was it, that was the end of the matter. That submission was rejected. There is room for the court to exercise discretion to grant relief. Now, the cases that a lot of tenant lawyers often rely upon are cases like bracking. But cases like bracking, as many of you will know, are cases about breaches of the public sector equality duty in a national context when considering important national questions like the revocation of a nationwide benefit. And what the Court of Appeal is telling us in Aldwick is you cannot apply those sorts of considerations indiscriminately to cases involving an individual tenant in the housing context. In the context of a typical possession action, the court will have available to it all the facts in the dispute and is perfectly equipped in many cases to make the assessment for itself. And therefore it can analyse the consequences of a breach more easily than in the context of a bracking type wide-ranging ministerial decision. So what the court needs to do is look closely at the facts of a particular case and determine if on those facts it's highly likely that the decision would have been substantially different if the breach had not occurred. And if the court can conclude that the outcome would not have been substantially different, then it will allow the possession claim to remain. So that's a quick canter through those two recent cases. And now I will hand over to Ruchi to deal with the case of Patrick.
Thanks, Ryan. Right, so I'll be looking at two cases, and the first one is London and Quadrant Housing Trust and Patrick. Now, I think it's important to go through some of the background facts here, because actually the timeline that you see in this case is actually the type of timeline that you see quite regularly in possession proceedings. So Mr. Patrick had an assured tenancy, and the trust issued possession proceedings against him relying on ground 14 owing to antisocial behaviour, and in particular harassment of a neighbour. Now, meanwhile, the trust had also applied for an injunction, the terms of which, in fact, Mr. Patrick had breached and admitted to having breached at a commercial hearing. And then shortly after, but in a different context, Mr. Patrick's solicitors had in fact said to the trust that he had mental health problems, at which point the trust asked for medical evidence, and in fact asked on 2 occasions, but no medical evidence was provided. And so then at some later point, the trust decided to amend its claim to include ground 7A, so the mandatory ground for breach of injunction. When Mr. Patrick then filed his defence, he pleaded disability, but provided no details of mental impairment. And it was only 2 days before the possession hearing that his solicitors then served medical evidence, which showed that he suffered from a history of schizophrenia. Now, when this came before the judge, and incidentally, it was the same judge who'd heard Mr. Patrick's commercial application, the judge basically noted the history of schizophrenia, but noted that Mr. Patrick's health had in fact been reasonably good for about 15 years. And then when it did dip, he had been offered a lot of assistance and medical assistance, but had failed to keep up with any of his appointments with mental health services. The judge also took into account the fact that, the very serious impacts that Mr. Patrick's behaviour was having on his neighbour. And so in all the circumstances, he made the order despite, the possession order, despite the potential breach of the PSED. Now, about 3 months after the possession order was made, the housing officer involved actually did carry out an equality impact assessment. And when the issue came before the High Court, it was just a single issue of whether the order should be set aside because the trust had in fact failed to comply with the PSED. But when it got to the High Court, Mr. Justice Durdana, who was the judge in that case, kind of went back to first principles and said, well, hang on, has the PSED actually been breached? And he wasn't satisfied that there had been a breach. And in reaching that conclusion, he looked at various factors. So, for example, he noted that, Mr. Patrick had legal representation throughout, including from quite early on in the proceedings. His solicitors had never responded to any medical requests. The only evidence that they did serve had been 2 days before the first hearing. And so that was the only point at which the trust could sensibly be expected to engage with the PSED. That being said, the High Court said that the PSED is not a trump card. So, the mere fact that this evidence was served didn't mean that the trust had to, in those circumstances, go through some elaborate formal equality impact assessment so late in the day, or indeed to pause proceedings entirely to consider this new situation. And that they were perfectly entitled to, as they had done, to consider the disability, but to continue to seek the possession order. The judge also noted that in any event, the trust would have had a further opportunity to consider the PSED when deciding on enforcement, which it had in fact done by carrying out that late assessment 3 months after the order. And the judge also said that actually, even if he was wrong on the first issue of breach, he was satisfied that any breach would not have led to a materially different decision. So just to focus there on that first issue of whether breach had been committed or not, it's quite interesting and welcome that the judge reached a very pragmatic outcome in this case. And as the judge himself recognised, that to do otherwise would allow litigants relying on PSED to deliberately postpone revealing a disability for tactical advantages until the last possible moment. And certainly, there was no suggestion that is what the solicitors had done in this case, but it is certainly something that I've come across regularly in my practice. So where disability may be pleaded, in the defence, but no evidence is provided until even the eve of the trial, and then all of a sudden the PSED becomes an issue, which wasn't much more than kind of one sentence in the pleading, and perhaps wasn't even mentioned in any of the witness statements. So it is certainly helpful to have this robust and clear decision from the High Court on what due regard means in such situations. The final point I would say here is if you do want a refresher course on the PSED, and I assume you do because you've all tuned into this webinar, I would urge you to read paragraph 42 of this judgment, because what the judge does, and Emma sort of done this for you already, is he sets out and draws out the various principles of the PSED that are most relevant in the context of possession cases. And it's here that he talks about, context specific, that due regard is a context specific term, and that lateness of evidence, for example, will impact on the discharge of the PSED. So I think it's quite a useful paragraph to look at if you are ever faced with the issue in practice, just to kind of refresh your memory of what steps you need to undertake. I turn then to my second case, which is Barnsley and Norton. So you're probably rolling your eyes at your screen now and wondering why I've included a case from 2011 in a case law update in May 2020. And you do have a valid point, but I do think it is actually a case that's equally relevant and important today. And it does address an issue that, again, crops up quite a lot in all our practices of late compliance, and whether late compliance can actually remedy an earlier breach of the PSED. I think particularly in the context of ASB cases where you need to act very quickly, and indeed in the context of overstretched housing teams or legal teams who may have missed some evidence of a disability prior to issuing proceedings, the principles from Barnsley and Norton become very important. So many of you will be familiar with the facts of this case. This was about dealt with a council that had employed the defendant as a school caretaker, and the contract provided for residential premises on the school grounds. He lived there with his family, which included a daughter who had cerebral palsy, and the council in fact knew of the disability and had in fact adapted the premises to suit the daughter's needs. But when the employment was terminated, the council sought to bring possession proceedings and indeed obtained an order, but at no stage did it give any particular consideration to the daughter's disability. So when this came before the Court of Appeal, the court said that, clearly the council had failed to have due regard to those disabilities prior to bringing proceedings, or indeed at any stage during the proceedings. However, the council could still give proper consideration to the duty in the future when discharging its housing duties to the family. And so on that basis, the judge was perfectly entitled to make the possession order. Now, this decision is captured in this sentence that I've got on my slide, and it's paragraph 34. And it's used time and time again by barristers like myself in court when we are seeking to persuade a judge that actually even if at the start of the proceedings things hadn't been perfectly done, the situation had been rescued by a late assessment. But one of the issues that does crop up when you cite Barnsley is that it is often said by tenant barristers that, well, Barnsley doesn't really sit right with the first principle of PSED. And you'll recall that Emma said that, the first principle really is to comply prior to taking a decision and to approach the issue with an open mind. And so, tenant barristers will often say, well, how can this possibly be done? How could you possibly have an open mind during the course of proceedings? Because clearly it's a foregone conclusion that you want to press ahead with getting a possession order. Now, I don't think that's necessarily true, and certainly that's not how judges have approached it in cases that I've been in. It obviously will depend on the kind of evidence you have. And if you are able to demonstrate that you have had a conscientious consideration of the PSED, even if it's late in the day, then surely you are able to satisfy compliance with the PSED. And I think it is important to remember here that the PSED is a continuing duty. It's not static or set in stone. So it does stand to reason that you can and should revisit the question, and in particular where, for example, you have a material change in circumstance. Now, while Barnsley has been around since 2011, and it has been cited with approval in the recent cases, particularly the ones that Ryan has gone through, it hasn't, the issue of late compliance, the issue of late compliance hasn't specifically been addressed by the Court of Appeal in those cases. But it's certainly implicit that it is good authority and that late compliance is good compliance. That being said, the issue has been raised again in an appeal that I'm involved with and due to be heard by the High Court in the next month. And it will be interesting to see how that pans out. It's being said by the tenant council that actually late compliance couldn't have been done with an open mind. But my initial view, as I've set out and hope, is very much that the that the court will simply confirm the Barnsley principle and take each case on its facts. So with that being said, I will now hand over to Andy.
Thank you very much, Ruchi, and also Emma and Ryan, because they've obviously provided a very good overview of what the Section 149 duty is and how the courts have been applying that duty. I suspect you may still have Ruchi's picture up, but that's just probably better for you. Can I also say that my bit is looking at the practical application of dealing with the public sector equality duty, and dealing with some of what Emma concluded her submissions on, as to how in practice officers dealing with questions of issuing possession proceedings or going for a warrant of possession should deal with these matters. It's obviously better to try and get in the position of a Powell and Decorum or a TM and Metropolitan Housing Trust case where there is no breach of the PSED than it is to deal with questions such as Durdana and Forward, where there had been a breach, and the questions are dealing with how does one then deal with that in the context of what happens with the possession claim or the application to stay execution. So I'll be looking at those issues. Just two minor points. You may see a slightly different design on these slides. That's not because I'm particularly very savvy on these things. I've just found the design button on the iPad. And secondly, if there is a noise in the background, I'm afraid my wife's just started her exercise regime and has got the headphones on, but it's better singing than me anyway. Starting with the Corporal Jones mantra, which is of course, don't panic. Something about the public sector equality duty does make people panic. And one of the things to remember is that however good you do it, however well you do it, it's going to be in the defence, because people will put it in there, normally just one line, to say that the landlord has breached the public sector equality duty. So this isn't about stopping these matters coming forward, it's about being able to respond to them in a better manner. And the quick key is therefore, don't be overwhelmed, we've already heard that in certain rare cases, you may actually satisfy it without even realising it exists. And I've always said a good officer looking at these cases in a proper manner will often deal with these kind of questions without even reference to 149 or realising it exists. What I would say is that it will often become the big issue in a case, and Ruchi and I know that from Powell. It's been clear from other cases as well, because it's one of many defences, but it becomes the only thing that is actually left on the table. And we've seen that with cases, similar cases like Hertfordshire County Council and Davis with Section 11 of the Children Act was one of 9 defences, and yet that was the only one that went through to the Court of Appeal. So it doesn't often mean that it's the main issue. And it certainly wasn't, for example, with Durdana, which was obviously a standard ground 17 case. But if we have a look at the next slide, it's worth just reminding ourselves what Lord Justice Patten said in Durdana, in the fact that it doesn't amend statutory powers and functions of a public authority. It does not limit or qualify the power of a housing authority to seek possession of premises, but, and this is a crucial bit of course, in deciding whether to take or continue such proceedings, so it can be invoked at various stages, and incidentally can also be invoked to try and invalidate something such as a notice to quit or a notice seeking possession. But in deciding whether to take or continue such proceedings, the authority must perform the duty of consideration which Section 149 imposes on it. So what does that actually mean in practical terms? If we have a look at the next slide, I've listed there 5 questions. I did think, if I was short of time, just saying to you the answers are yes in an ideal world, no, 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 review. But perhaps it's only fair to look at that in a little bit more detail. Question 1, do I need to read and understand Section 149? Well, obviously, yes, is the clear answer. In an ideal world, the officer would understand it, would appreciate what it actually means. And it will be remembered that in Powell, at paragraph 38 of the judgment, reference was made by Lord Justice McComb to the fact that the officer had expressly referred to Section 149 in her assessment, a proportionality assessment of the case, which had to be done late in the day. And therefore, when there are arguments about whether, because of questions and answers in the cross-examination, she really understood the public sector equality duty, the judge was prepared to say, look, she mentioned it expressly, and therefore he took the view that she clearly did understand it and applied it in that particular case. As to the question, the second question, do I need to read cases dealing with the PSED? Well, obviously, it's a good idea to read cases because things do change. But I think we have got to a point now where it's fairly clear what the jurisprudence is. It's fairly clear that the public sector equality duty is important. It's fairly clear that it doesn't necessarily mean that a possession claim or a stay of execution will be decided if there has been a breach of the public sector equality duty on that basis. It could still be the case that possession is ordered or the stay is not allowed. And that is quite clear from the authorities. As Ruchi says, there is potentially an open question as to ex post facto assessments, although my own view is that it's quite obvious from the jurisprudence we've seen to date that you can do late assessments, and that is not necessarily going to be a predetermined question. And as Ruchi also said, paragraph 42 of Mr. Justice Turner's judgment in Patrick made it quite clear that in fact that there should be no problem with that. Question 4, will a proportionality assessment suffice? I think the important question here is to remember that a proportionality assessment is not the same thing as a public sector equality duty assessment. They may well be in the same document, and there's no reason why they shouldn't be, and I mentioned the officer in Powell doing so, but a proportionality assessment will not in itself be sufficient. Because they're obviously answering different questions. Proportionality assessment is looking at whether there were less intrusive means to deal with such matters when it comes to proportionality, whereas of course the Section 149 requirements is to have due regard to those matters, whatever the outcome of those considerations are. So certainly do it in the same assessment, but it certainly isn't sufficient to say I did a proportionality assessment. Lastly, what happens when circumstances change mid-case or mid-process? As has already been indicated, clearly if matters changed, it requires reconsideration. So you may have issued a notice in a perfectly proper fashion. You may in fact have issued proceedings in a perfectly proper fashion, but things change which require you to consider whether to continue those proceedings or whether to enforce them. And of course, as Mr. Justice Turner said in Patrick, there may be situations where, because through no fault of your own, you have a late notice of an issue, it means that it's difficult for a defendant to challenge the notice or the issue of proceedings and has to rely on the fact that the proceedings should not continue because there was no basis and no engagement of the PSED until the officer was aware of the relevant facts. So those are the answers to some of the questions. And if we go on to the next slide, some pointers that I've suggested. Firstly, of course, be aware of why possession is being sought. And by that, what I mean is that it's fairly obvious, of course, if you're pleading ground 12 or 14 for an 88 Act case or ground 1 and 2 for a 85 Act case. But in an introductory tenancy case or a Section 21 case, it's not so clear. So be clear as to why you're doing it, because that may give you a good reference to the particular protected characteristic as in issue. And don't forget, of course, that we have focused for obvious reasons on disability, but there are other protected characteristics. You know, there may be issues of race, there may be issues of sexual orientation, there may be issues of gender reassignment. These are issues that would have to be addressed. And really what the officer is saying is, do any of these come into play? Are any of them relevant? Because not every case, of course, and indeed most cases won't. Most cases will not engage the PSED. That's just reality. So one has to think about first, does the issue come into play? The next suggestion is that really what you're asking is, did you consider whether they merited a different approach than normal? In other words, when you focused on the question, for example, of the disability, how did that affect how you dealt with the case? How should it have affected how you dealt with the case? Could you have done something to make the breach less likely? If somebody, for example, was making a lot of noise because of their disability, were they in the right property? Could you look at soundproofing or whatever? Although I stress here, of course, that the PSED is not about results, it's about regard. Did you think about that issue? Was third-party evidence considered or sought? And another good example is, again, Powell, where the officer there had done like most good officers will do and looked into the person's health issues, tried to engage with people, but they wouldn't engage. And of course, the defendant himself wouldn't engage. And therefore, she couldn't be criticised for not having a crystallised view as to the individual's disability. And it wasn't held against her, of course, and it was treated as being a perfectly proper thing to delay the assessment. And of course, a question that most commonly comes up is, what is the prognosis for the defendant if evicted? Because everything else, of course, is looking at how we got to this point. But of course, the repercussions of possession proceedings may well be, and often will be, eviction. It could be a suspended order, but it may well be eviction. And of course, that at least has to be thought about in the context of the person's protected characteristic in issue. And if we could go to the next slide, please. So just to make it clear, there is reality in the court's approach to these matters, and it's one of the nice things. I mean, just as with Article 8 matters, which was decided effectively by Ryan's case of Thurrock and West, there is a reality that has struck the courts. In other words, arid, dry defences should not be encouraged. It won't stop them, but it shouldn't be encouraged. So what we know is that the breach may not be fatal. You know, we've got the example there of Aldwick and Forward, which you've heard about. We had in the Children Act context in Hertfordshire in Davis, an admitted breach of the Section 11. And the first question to my opponent in that case was, what do you want us to do about it? It was a case where the person had no rights of occupation. He'd lost his job as a caretaker, so lost his right of occupation. So Section 11 had been breached. So what? What do you expect us to do? Because of course it didn't affect the fundamental fact that they were trespassers. And most crucially, as Ruchi has mentioned, context is absolutely crucial. Lord Justice McComb was in Bracken, and it is a bit boring to keep seeing these array of cases dealing with very important national issues and government policy being equated with a decision as to whether to seek enforcement of a possession order or whether to issue proceedings in the first place. They are clearly different, and context is clearly crucial, as is the reality of housing law and the way that housing officers approached their duties. So context is very important, and it's not a duty to achieve a particular result. So unlike proportionality, for example, where one can argue that the landlord should have done this or should have done that, this isn't about saying, well, I don't agree that if they had thought about it, they should have done this. It's about saying, was due regard had to that matter? And if we can go on to my last slide, it's a citation from Lord Justice Dyson in a non-housing case of Baker, the Secretary of State for Communities and Local Government, as they then were. It's the duty to have due regard. And in my view, and you can see references to this and this approach, particularly by Mr. Justice Turner in Patrick at para 42. But Dyson says, in my view, it's to regard that it's appropriate in all the circumstances. These include, on the one hand, the importance of the areas of life of the members of the disadvantaged racial group that are affected by the inequality, and on the other hand, such countervailing factors as are relevant to the function which the decision maker is performing. And can I just say that in the context of what is often an ASB case, but not necessarily, those countervailing factors are going to be issues such as the impact on neighbours, the impact on staffing, the impact on anyone else of that person's antisocial behaviour. That's obviously weighed into the mix and considered as a whole. What I would conclude on in terms of dealing with these matters is that the public sector equality duty is important, and I don't think anyone would wish to underestimate that. It's important that officers are aware of it, and it's important that officers address it. However, there is a danger of becoming overly analytical about it, and a degree of common sense has to be brought into the mix. And as I say, a good officer will know, for example, that certain tenants have issues and will have considered those issues when considering how to deal with the problems that have been raised, whether they're rent arrears or antisocial behaviour or whatever. And in those contexts, it shouldn't be an insurmountable problem for people on the ground to deal with. It's likely to be still part of defences, but it's unlikely to be something that's going to stop the claim in its tracks. And that's the history and the lesson of the litigation that we've seen so far. So I conclude my bit, and what we're concluding with, which you'll see on the next slide, is some questions, and more importantly, some answers that some of you wish to have to your questions. And I have got a few of them in front of me, and if I'm not going to be answering them, or many of them anyway, I should say, I'm going to pass to Emma a question I have from Diane Murphy, which is, what specific questions should be asked on proportionality assessment for possession claims to comply with the PSED? So Emma, if I can pass to you that question.
Yeah, thanks very much, Andy. I think it's hard to sort of be too specific about this, primarily because I think you don't want any kind of checklist to be too rigid, because if you only have a list of specific questions that you're going to ask, there's a possibility that you might miss some out that are relevant in one case and not in another. Having said that, I do think having some sort of template is useful and a good idea and good practice, because it does encourage the decision maker to go down and go through that logical thought process. I mean, I don't think it's the time now to set out question by question what should be included, but I think fundamentally what the person who's making the decision needs to know is, firstly, what is the relevant protected characteristic that's engaged in the case. Secondly, how is it actually impacting on the tenant in a way that is relevant? What are the consequences of that protected characteristic for the tenant? For example, mental illness might be contributing to, as Andy said, loud noise or aggressive behaviour. Thirdly, what impact would making a possession order have on the tenant? Would they be more negatively affected than somebody who didn't have that characteristic, and why? What are the countervailing factors? So what are the reasons why you might not take possession proceedings away against the course of action you're taking? Is there, number 5, a reason to treat this tenant with a protected characteristic more favourably than you would otherwise do? And then I suppose making just an overall balance of those factors and reaching a decision. So I think that's the kind of broad outline. We'd obviously be able to break it down a bit more within that, and something that I'm sure many of us on the team would be able to advise on in an appropriate case if that was thought up for.
Thank you very much.
Take over.
Thank you. There's also a question about the difficulty that certain people have had in getting information, and what happens where the landlord is unable to get the information despite their best efforts, whether that's because of the tenant or because of the support workers or whoever. And perhaps if, Ryan, do you want to have a look at that one?
Sure. I think that's a question from Caroline. The first point, Caroline, you've asked your question in the context of a tenant who has suspected drugs and or alcohol dependency. Of course, the first point to make there is that drugs and alcohol dependency are specifically excluded from the definition of disability within the meaning of the Act. However, you've got to be very careful in drugs and alcohol cases because, of course, any condition that underlies those addictions, which may be causing those addictions, could very well fall within the definition of disability. And in addition, if drugs and alcohol dependency are causing other conditions, such as depression, which they often do, then the depression itself is a relevant disability for the purposes of the Act. That's just by way of introduction, because I think the crux of your question is about how you get information out of people. And that really is the million-dollar question. If you are a local authority, you should have an information sharing protocol in place between departments. So your social services department should be willing to disclose information that is relevant to the exercise of your functions so far as they relate to your housing department. If you're a housing association, I accept the position is a little bit trickier, but even there, although I'm not an information expert, there is scope for agreeing such protocols and for social services departments to be able to share information where required. And if you are finding that you're hitting a brick wall, it's often a good idea to refer that up the chain, up the managerial chain, so that the heads of service can talk to each other, or the head of social services and the head of the relevant part of the housing association can talk to each other about implementing some kind of information sharing protocol. But at a more basic level, if you can show that you've made your inquiries and you've got an audit trail of those inquiries, so letters to the healthcare trust, letters to the GP, nothing coming back and nothing being volunteered in terms of evidence of a diagnosis, then you record that on your PSED and Equality Act assessment, and you confirm, whilst carrying out that assessment, that you don't have a sufficient basis to conclude that this person is disabled. But then it's quite often a good idea to proceed, so far as the Equality Act assessment is concerned. I know it's a bit more difficult with PSED, to then go on and consider, well, notwithstanding that you don't have a confirmed diagnosis, if there is a diagnosis here and if the person is disabled within the meaning of the Act, is it nevertheless a proportionate means of achieving a legitimate aim to go on to consider possession? So I hope that helps. It is difficult sometimes to get the information you need, but there are ways around it.
Thank you very much, Ryan. And can I just say as a follow-on, just 2 quick points. One is that in terms of serving the assessment, which was a follow-on question that I think Caroline had, clearly if you've done a written assessment, then you're going to have that as part of your disclosure, and so would normally go in that disclosure. If you've got an ex post facto assessment, as the case proceeds, as would have happened in Decorum and Powell, for example, then it's something you would put exhibited to a witness statement or such like. But clearly, assessments of this kind are part of the disclosure that you would normally produce. And I think it's also important to say that if you've had a possession order, so we're talking about the enforcement stage, if that possession order involved, for example, disability issues, the court is likely to treat it as having already been dealt with PSED, unless it's a change of circumstances. And that was one of the things in Powell. Disability was raised in the possession claim as part of a defence. The parties agreed that a suspended possession order would be appropriate. And although the PSED wasn't expressly raised, the Court of Appeal said it must be treated as having been accepted as being complied with, and there'd be no change of circumstances after the possession order up until the point of the warrant, and that therefore there would be no reason for the authority to carry out a fresh assessment. I'm going to now pass to Ruchi to deal with a question from James Hallinan. Ruchi.
Thanks, Andy. I think the question from James is, would it be unusual for housing clients to have no system in place for the PSED, to carry out the PSED, or to have any idea what the PSED is? And I think the short answer is that, in my experience at least, it would be unusual. Maybe not 5 or 7 years ago, but certainly, given the state of play now, it would. And housing officers are not expected to be able to provide a legal thesis on the PSED, but they will be expected to know what the duty is and what their obligations are. And certainly the housing team at Cornerstone regularly provide this kind of training to officers, and we have done in the past. And so, if that is a concern, then please feel free to come to us to provide that training. Thanks, Andy.
Thank you very much, Ruchi. Can I just, there's one point raised about whether people are using the PSED for their own advantage. and that it's a very weak standard, due regard as a very weak standard. I think there's some truth in both of those comments. Due regard, remember, as we've said repeatedly, it's not about a result. It's about having a proper regard to the circumstances as and when relevant, but also taking into account the countervailing factors. So I'd agree that it's not the highest standard, and of course it's not for the court to substitute its own view. As for people taking advantage, I'm not naming names, but it's true to say that there are certain defences, which I could tell you who's drafted it without seeing the name, and there are certain cases, as I say, you get, and it's often put in as a backstop, really. And so I'm not so sure that they're necessarily taking advantage, but I think they're putting it in there because they want to have something if they don't succeed on other grounds. So there is some truth in that, I think. Can I pass on to Emma, who has a question, I think, for Margaret Kinzo to answer? Sorry, Emma, are you there?
Yeah, no, I just realised I was on mute there, sorry. Yes, I think there were two I was going to take together, if I can just find them. I think one was about whether we'd recommend carrying out a PSED assessment before seeking an antisocial behaviour injunction, because obviously that's something that is usually quite urgent and can be quite tricky. And then the other question, I think, related to that was about doing it in cases of unauthorised occupancy. I think the easy, and subletting as well, sorry. I think the straightforward answer is that the public sector equality duty applies to all functions of public authorities. So it should really be something that is considered, whatever type of case it is, whatever the reasons for seeking possession, or whether it's an injunction that you're looking at rather than a possession order, something that should generally be factored in as best you can. If it's something that is urgent, then obviously it may be difficult to go through the same full assessment that you might do if you have more time. But I think fundamentally it is something that you need to do to the best of your abilities. And obviously, as the case develops, and if evidence then comes forward once you've initiated those proceedings, it is something that you would then want to reconsider. But I think, yes, in both of those cases, it's something that needs to be considered.
Thank you very much for that. There was, by the way, some question as to the depth of inquiries. I think this is Alex Loxton, and an example of a case she had. The depth of inquiries to make in, for example, somebody's disability, and the problem, for example, in that case where the GP wasn't being particularly forthcoming for no doubt very good reasons. The trouble is, I mean, it's obviously up to the individual judge to decide whether, in fact, the officer and the landlord have made sufficient inquiries or have been put on sufficient notice to require them to make those inquiries. Clearly, you know, if you read Powell, it will give you an example of a situation where an officer made not just one contact with the GP, but many contacts with them and indeed with others. So it is very much fact-specific, that question. I think all you can really say is you must just try and do the best you can to make the necessary inquiries. But ultimately, if there is a lack of engagement, whether from the defendant or from the authorities that you're seeking information from, you can put that forward to say, look, we tried our best. And it rather supports the proposition, as indeed I would say Mr. Justice Turner did in L&Q and Patrick, that you can make ex post facto assessments when you've got that greater information some way down the line, which often happens when they're represented and they get expert reports. There was a question, I think, from Asher Pomeroy, which I think Ruchi's going to have a look at. Ruchi, have you got that question?
I'm just pulling it up.
You're scrolling now, aren't you?
Oh, sorry,
I think in fairness to Ruchi, I think I'd volunteer to answer that.
Did you?
Yeah, so as not to put her on the spot unless she particularly wants to, but I'm also conscious of the time because it's midday. So I think we'll just answer this one quickly and then we'll probably have to call it a date there. So Ruchi, I don't know if you want to do it or would you like me to just cover it briefly?
I'm happy for you to take over because I'm still actually looking for the question.
Yeah, that's what I thought. Yes, the question from Asher Pomeroy was essentially explaining that there is already a proportionality assessment which they've developed and they use it for cases where they think there's a potential disability, and essentially wanting to know firstly, is there a mechanism to check that I suppose checklist or assessment document to ensure that it's sufficient? I suppose the answer to that is if you want to have some advice on that, then we're here to help you with it. The second question is that it's not completed for all cases, and should that be done? And then similarly, it's currently only done when serving notice of seeking possession on vulnerable tenants, but should it be done for all notices of seeking possession? I think it's always good to have that kind of checklist or approach as part of the decision-making process. It's always good practice to consider whether you need to go through that full assessment. So I certainly think it should be part of the decision-making procedures. Obviously, if there isn't a relevant protected characteristic in the case, you don't need to take it further and actually go through the assessment. But I think it's certainly good practice to have that as part of your procedure, so that you know that you've addressed your mind to those questions insofar as they're relevant to the case that you've got before you. So I think with that said, we've, I think, answered the majority of the questions. There are a few that we haven't been able to cover. Do feel free to get in touch with us after this is finished if you want to follow up further. But otherwise, all it remains for me to do is to say thank you to the rest of the participants and to all of you for listening. Yeah, hopefully see you again another time for another one of our webinars. Thanks very much.